Hello, everyone. It's really a pleasure to have you with us for this month's edition of our monthly webinar series. Welcome back and thank you for joining us once again. Your participation in today's conversation is most appreciated. And indeed, if you're unable to participate today, you can always get the replay on our YouTube channel and even engage with us in the comment section. My name is Elojo Joy, and I'm a legal intern at Adun Legal. At Adun Legal, we protect your business, technology, intellectual property, and your future. That means we work closely with startups and founders to navigate regulatory uncertainty, especially in fast evolving and highly regulated sectors. Our theme for the month, Litigation Proofing Your Startup. Our theme for the month remains litigation proofing your startup. And with this webinar, we are intentionally creating room for this important conversation to help startups and founders realize structural gaps that could incur costly litigation in the long run if overlooked. Today's session is designed to be practical, insightful, and forward-looking. Now, whether you're a founder, operator, startup, in-house counsel, compliance professional, or simply trying to understand what litigation proof your startup entails, you're in the right room. Many founders imagine threats that can destroy their startup. They often think about market competition, lack of funding, or product failure. Rarely do they imagine litigation as a silent force capable of dismantling years of innovation. Yet in reality, many startup disputes are not sudden accidents. They are predictable consequences of structural gaps that were ignored during the early stages of building the company. Most startups begin with speed and optimism. Founders rush to build products, attract users, and secure investors. And in that excitement, legal structure is often treated as an administrative detail that can be addressed later. Agreements are made verbally, equity is discussed casually, intellectual property ownership is assumed rather than documented, and governance frameworks are postponed until the company gets bigger. Unfortunately, law does not operate on assumption. When expectations collide, the absence of clear legal systems turns misunderstandings into disputes and disputes into lawsuits. Now, the reality is that litigation rarely begins in the courtroom. It begins months or even years earlier when critical questions are left unresolved. Questions like who owns what percentage of the company? What happens if a founder leaves? Who owns the intellectual property behind the product? How are decisions made when founders disagree? When these questions are not addressed early, the startup unknowingly builds its growth on legal ambiguity. Founders conflicts illustrate this problem clearly. Research and industry commentary consistently show that disputes between founders are among the most common risks in startup impact. And these conflicts often stem from unclear equity structures, undocumented responsibility, or shifting expectations about contributions and control. Now, when disagreements escalate, they can trigger allegations of breach of fiduciary duty, ownership battles, and prolonged litigation that drains both financial resources and team morale. The damage rarely stops here. That's the interesting part. Investors view internal disputes and legal instability as serious red flags. A startup entangled in litigation appears unpredictable and poorly governed, which can lead to withdrawn investment opportunities, reduced company valuations, or collapsed partnerships. And in extreme cases, unresolved conflicts can paralyze decision making within the company or force the business into premature dissolution. Now, beyond founder conflicts, modern startups face an expanding landscape of legal exposure. Data protection regulations, intellectual property disputes, employment disagreements, and platform liability issues can all become sources of litigation if they are not carefully managed. For example, businesses that collect and process user data must comply with strict privacy laws, and failure to implement proper safeguards can lead to regulatory penalties and even reputational damage. Now, these realities reveal an important truth. What's that truth? That truth is simply that litigation is rarely the root problem. It is the final symptom of deeper organizational weaknesses, unclear ownership structures, weak governance systems, undocumented relationships, and poor compliance practices. And by the time a lawsuit appears, the real mistakes have usually been embedded in the company's foundation for a very long time. And this is why the concept of litigation proofing is so important for startups. For founders, this shift in thinking is powerful. Instead of seeing legal work as a cost incurred after problems arise, it becomes a strategic tool for protecting the company's future. Well designed legal systems can prevent internal conflict, reassure investors, protect intellectual property, strengthen regulatory compliance, and create a culture of accountability within the organization. The most resilient startups understand this early. They indeed recognize that a company is not built only on technology, capital, or marketing. It is also built on legal clarity, the invisible framework that holds relationships, rights, and responsibilities together as the business grows. Now, against this backdrop, we have with us today a distinguished speaker who would pilot this conversation this fine afternoon in the person of the phenomenal barrister Hilda Obasanya, and she'll be taking us through the nitty-gritties of all we need to know regarding litigation proofing your startup. Now, we know you must have seen her profile on our LinkedIn page regarding this webinar. However, I would like to go over it again so that we are abreast with who our speaker is. Now, Barrister Hilda Obasanya is a Nigerian commercial lawyer and founder of HT Legal Advisory, a firm that advises businesses on contracts, regulatory compliance, corporate structuring, and commercial transactions. She works with entrepreneurs, startups, and growing companies to structure deals, manage legal risk, and build commercially sound operations. Hilda also writes and speaks on practical legal strategies for businesses with a focus on contract drafting, risk allocation, and the strategic use of law in business growth. Now, we are beyond elated to have Barrister Hilda in our midst today, and without taking any much time, I would be handing over to Barrister Hilda Obasanya to take us further on this discourse. Thank you so much, ma'am. We are super excited to have you with us this afternoon, and we can't wait to hear all that you have for us. Thank you, ma'am.
Thank you so much, Joy. Thank you to Adenigo for having me here. It's a pleasure of mine to be here to speak on this topic. And yes, so I believe we can get right into it. So that was a great introduction from Joy. So she's basically summarized the core points or the core elements in this webinar today. So let's get into it. The topic is litigation proofing your startup. Basically preventing disputes before they arise. And from the subject matter, two keywords shine through. So the first is litigation or litigation proofing, and the second is startup. So when we say litigation, what do we mean? Litigation is a dispute resolution mechanism. So it simply means that when two people, whether they are what you will call regular human beings or people or institutions designated as what we will call legal persons, so companies, businesses designated by law as legal persons, when they have disputes and they choose to resolve that through the courts, we call that litigation. Now, what do we mean by startup? A startup simply is a business that is, so the first thing is it's a business, it's a company. However, there are distinctive features. So a startup is different from a traditional business in the sense that it is high growth. So it is the core service, the core products of the business is structured in such a way that the company is made to be high growth. It scales very quickly. It is disruptive, and then um, it is technology driven. Yes. So that's the distinctive feature, or those are the distinctive features that separates a startup from a traditional business. So a traditional business, a brick and mortar business, you could say, for example, a bank, a supermarket, a fashion store. So those are traditional brick and mortar businesses, you know. But a startup is high growth, scales very quickly, and uses technology. An example would be fintech, edutech, those companies that are majorly driven, or whose products and services are majorly driven by technology, and they scale very fast. So when we say litigation proofing, what does it mean? And the question that should come to mind is, can I really litigation proof my startup? Is it ever possible that throughout the course of running the startup, from incorporation right to growth stage, right to exit, is it possible that the stakeholders do not have recourse to the court system due to conflicts? So that's a question I want you to think about, to meditate on, and to come up with an answer, perhaps before the end of this webinar session. So the next slide. So I have stated here, I don't know if there's someone controlling the slides for me.
Okay, wow. So that was a technical glitch. My apologies for that. Can everybody hear me? Am I audible enough? And can you see me? Okay. So in my next slide, I have stated that startup litigation risk is typically a byproduct of accelerated growth without corresponding investment in compliance systems, contractual clarity, and governance frameworks. So when we talk about startup litigation, these are what causes litigation or what would lead to litigation. The fact that the company is growing at such a high level, like I said initially, a startup scales very quickly. And many times, because the startup scales quickly, compliance cannot match up. And then so you find founders, co-founders, owners of these companies not putting the necessary structure in place to support the growth that they want. And then I've highlighted a case study. So let's look at the next slide. And this is a company that is dear to my heart, a company whose growth I followed right from inception till when dispute started. And the name of the company is 54 Gene. Now, 54 Gene is a genomics company. It's one of the pioneer genomics, if not the pioneer genomics company in Nigeria, and one of the top genomics company in Africa. And what do? They get genes, your genetic material, and that genetic material is used for a lot of things, testings, you know, creation of appropriate pharmaceuticals for Africans. Now, in 2025, a dispute was made public between the founder and the what we would call the investor company that also had um, what I would describe as majority board control. At this point in 2025, the founder had been kicked out of the company, so he was no longer CEO. And there was a proposed transaction to sell the assets of the company, basically genetic materials, reportedly valued at $3 million. And the company sued, of course, allegations left, right, and center. The point being that one, the person who had founded the company was no longer a part of the company, that had been kicked out because the investors had exercised what was known as veto rights. And secondly, the assets of the company were, and these are genetic materials, were going to be sold to a foreign company. And at the time, the CEO founder was not in a position to exercise any power because he was already out of the company. This was a company that was once valued at $117 million, raised over $45 million in funding, built Africa's largest biobank, and played a significant role in scaling Nigeria's COVID-19 testing capacity. Ultimately, the company collapsed. So here's a reality check. Many times, founders, startup founders, co-founders, team members, they believe that startup fail because of maybe no product market fit or zero funding, or so maybe not even zero funding, say partial funding. You are able to have a successful pre-seed Series A, but then zero Series B, zero Series C, no funding comes in continuously. And because of this, people always assume that startup failure is either linked to product market fit or lack of funding, or even sometimes, regulatory interventions, inconsistent government policies. But in this case, 54 Gene's case was not a failure of lack of funding, even though funding played a role. It wasn't because there was no product market fit, because their products and their testing capabilities were already in use and on a large scale. It was because there was no legal structure in place, or there was no appropriate legal structure in place for the type of growth that 54 Gene was aiming for. And so that's a lesson for any startup founder, any entrepreneur, anybody building a high scale business, is that yes, funding can be a problem, lack of product market fit can be a problem, inconsistent government policies can be a problem, but many times it's preventable legal exposure. So, what does litigation proofing mean? I asked the question initially, which is it possible to not um, have to consult the court system if dispute ever arises? And disputes will arise because, again, companies are made up of individuals, they're made up of different complex relationships. So a company is made up of founders, it's made up of shareholders, is made up of, and shareholders can be promoters themselves, can be the founders themselves, can also be external investors, which can be VC, that's venture capitalists, or it can be private equity. You have creditors, you have employees, you have vendors. So a company is made up of complex relationships. And in the course of the company's journey, the course of the startup journey, disputes are inevitable. And so the question I asked was, is it possible to not resort to litigation? And so here I've stated that it is impossible to eliminate risk in business. There are different types of risk, financial risk, reputational risk, um, governance risks. However, as a founder or co-founder, you can reduce your exposure, you can allocate risk properly, and you can create enforceable structures. So when we talk about litigation proofing, it's a it's what we can call a preventive measure rather than a corrective measure. Is to say at the start of your venture, at the start of your enterprise, at the incorporation of your startup, what can I do? What measures can I put in place to ensure that I am less and less exposed to risk? What can I put in place to ensure that I allocate risk properly amongst the different complex relationships that the company will experience or the company would have? And what are the enforceable structures that I can put in place? So, what are the common litigation hotspots? The first I have on my list here are co-founder disputes. So disputes between shareholders, if it is a company or a startup that has been incorporated with two or more shareholders or with two or more equity holders. And the first here is equity split without documentation. So you're a startup owner, you have an idea, you're thinking of the perfect person to start the business with. And in Nigeria, typically what we do is we just find someone, we put their name on the CAC document as a shareholder, probably just give them like 10% to 20% of the company without any further documentation. So why should you have 20%? What exactly have you done? That 20%, what does it translate to? Does it translate to 20% of voting rights? Does it translate to 20% of what we will call dividends or profit sharing? What exactly does 20% translate to in terms of decision making? So when you have equity splits on incorporation documents without further documentation, what we can call, for example, a shareholders agreement, then that is a common litigation hotspot. The second is vesting issues. So because the structure of the system we operate in Nigeria, we have a nominal capital system where without proof of impute or without proof of consideration, you can list a person as a shareholder. And automatically, a person is listed as having 200,000 equity out of 1 million equity or 1 million issued shares. It means, or this translates to 20% equity. Without further documentation, it means that all the shares are vested at incorporation, which can be problematic. because what if the co-founder decides to exit the business? It still has your shares, and then we know that shares in Nigeria, it's either they are transmitted upon death, or they are forfeited, or they are transferred, because shares are personal property. It's not something that you can just recall at will. Now, once, in the absence of further documentation, vesting issues can happen, or disputes are touching a co-founder not picking up their slack, but already have all their shares fully vested as per the CSC document. Those are common, or that is a common litigation hotspot. The third is exit scenarios not defined. So, what is exit? Exit basically means, how does a founder, a co-founder, or an investor, how do they leave the business? Further investment documents, shareholders documents, we say, oh, these are exit scenarios, or these are exit triggers. An exit can be triggered by merger with another company. Exit can be triggered by an acquisition by another company, and then we sell our shares, or we purchase our shares, and we're paid, a, compensation. We can cash in our equity. Where exit scenarios are not defined, which, of course, when you incorporate a company, what you have are your memorandum and articles of association, which don't necessarily define exits. So if a startup is acquired, if a startup is um, merged with another company, or if the co-founder opts and leave, what does that translate to? So this is a common litigation hotspot. Again, rules and decision making. With shareholding, with equity comes um, certain rights, because the power of a company is split between two organs. You have the shareholders, then you have the board of directors. So equity grants you a level of decision making. If this is not properly defined in a document, it's a common litigation hotspot. Also, breach of fiduciary duties. Then we have IP disputes. Again, ownership of IP is a common litigation hotspot when it comes to startups. I am the principal founder. I have come up with the idea, and then I'm looking for Mr. X or Mr. Y to partner with me as a CTO, as a technology officer, or a CFO, a chief financial officer, or a CMO, a chief marketing officer. I'm looking for 4 partners or 3 partners to hold these offices and develop this startup with me. But I developed the concept. So in a situation where I have not copyrighted my concept, trademark, my brand assets, there's no document really highlighting who owns what. A dispute of such ownership of IP is a common litigation hotspot. Again, no assignment from developers or contractors. In Nigeria, we operate a system called the work for hire system, meaning when you hire a staff or hire an employee, whatever IP is developed during the course of employment, and most especially within work hours, are treated as work for hire. Now, not every country operates the system, especially if you're a startup. So this is something you should take note of, especially if your startup is registered in 2 jurisdictions, maybe Nigeria, Delaware, Nigeria, California, Nigeria, UK. So work for hire in some other jurisdictions are specific contractual elements. You have to specifically put it in your contract of employment. If not, the creator of the IP owns the IP. So where you don't have a document that assigns IP from creators, from employees, that is a common litigation hotspot. Again, using third-party content without license, your brand is not trademarked, and then your co-founders or your employees do not sign confidentiality agreements. That is a common litigation hotspot. Because in the absence of NDAs, your trade secrets is up for grabs. We also have investor conflicts. Ironically, co-founder disputes and investor conflicts are the 2 top common litigation hotspots. Whenever you see a startup embroiled in a litigation dispute, these 2 are the culprits. So, agreements on funding milestones, for example, anti-dilution provisions, fully negotiated governance right? Exit disagreement, these are common litigation hotspots. Now let's talk about poorly negotiated governance rights, for example. Many times when a startup gets funding from VC or PE, they want board control. They want to be able to exercise veto rights. And what veto rights do is that one, the investor or the investors um, have the right to kick out the CEO or the founder. They have the right to nominate directors. They have the right to accept or reject funding rounds. So if your investor contracts are not properly structured, and if all of these that I've highlighted are not properly negotiated, then litigation is inevitable. We also have employment or talent. So we classify contractors. For example, are your employees full-term employees? Are they part-time employees? Is it a triangular employment? These are things that could cause litigation. So confidentiality, I've mentioned this before, confidentiality and IP assignment clauses, with termination provisions, wrongful termination, discrimination and harassment. These are common litigation hotspots that need to be clarified, very defined, explicit, explicitly mentioned and highlighted in employment contract. The last but not the least are regulatory issues. And the honest truth is regulatory issues are divided into two parts. So you have regulatory issues as touching government policies, which honestly they're out of your hands as a startup founder, except you belong to a lobbying group where government decisions and government policies can be made in your favor. But the other part we'll be focusing on is regulatory compliance. So, for example, industry specific licenses ignored. Um, just being able to keep up to regulatory timelines. Are you filing your annual returns on time? Are you filing your VAT returns on time? Are you filing your CIT, WHT returns on time? Data protection breaches, if your startup is involved with collecting personal identifier markers, information as touching people's identity, what are you doing as touching data protection? And again, cross-border operations without structure. This is something I've experienced or I have engaged with a lot this year with companies that are registered in multiple jurisdictions. If a company registered in multiple jurisdictions and one company, for example, your company in Delaware is offering services to your company in Nigeria, you need to have what we call an intercompany services agreement. In the absence of this, this can, raise transfer pricing issues or double taxation issues. So these are common litigation hotspots that founders and startup owners need to pay attention to. So, what then is the litigation proofing framework? What are the things you need to pay attention to? You need to pay attention to your structure. Structure is something that you cannot overemphasize. So, when you talk about structure, you're talking about from incorporation. You know, what is your equity structure like? What type of what type of shares do you have as an incorporation? Do you have just equity? Do you have preference shares? Do you have redeemable shares? Under the CAMA, which is the Company and Allied Matters Act, these are types of shares that have significant, they are significant. They have their distinctive features, which every startup founder must understand. So your co-founders would most likely go um, have equity, which is what we call ordinary shares. Your investors will most likely want preferential shares, which entitles them to earn dividends ahead of any other shareholder. So you need to structure your company appropriately from the onset, right from incorporation. Then you have contracts. Again, like I said, there are multiple stakeholders. So contract with your co-founders, contract with investors, contract with third-party vendors, contract with employees, contract with creditors. Again, understanding that equity is not the only way to raise funding. You can also raise funding via debt. So you need to have your contracts on a lockdown. It's allocation. So basically, risk allocation talks about how you allocate risks in your contracts, your indemnity caps, your liability caps. These are clauses that every contract should have. Then again, control. So when we talk about control, we're talking about governance provisions. How our board members appointed? What powers should they have? What are the limits to those powers? So yes, then compliance, like previously stated, compliance in terms of taxes, compliance in terms of your company itself, with the company's affairs commission, with the corporate affairs commission rather. Um, your compliance if you are in a specific industry. So if you're a startup in education, a startup in oil and gas, a startup in the financial services, what does compliance look like for you? And what are the things you need to do to ensure that, for example, you're meeting deadlines, you're paying fees as and when due. Those are litigation proofing tactics. Final one, which must not be overlooked, is the operational discipline. And basically, this just talks about documentation. How do you keep your books? How do you document changes, minutes, resolutions in the company? How do you document? Basically, that's what operational discipline is about. So, when is the best time to involve a lawyer? Is it when you've made money? Is it when you've grown to a certain stage? Is it during your Series B, Series C, Series D, or Series Z? The best time to involve your lawyer is at the very start, right before incorporation, right from when you conceived the idea for the business. That is the first time and the best time to involve your lawyer. So let's look at a practical checklist. Do you have signed founders agreements? Do you have IP assignments from all contributors? Do you have standard contract templates? Do you have clear payment and liability terms? I did add here that do you have clear and explicit agreements with your investors or with your creditors? And then do you have your regulatory compliance map? You need to ask yourself, what is the cost of preventive measure versus risk? So the cost of proper structuring, as I've stated here, is far greater and far outweighs the cost of one dispute, the cost of one regulatory fine or multiple regulatory fines, or the cost of a failed deal. Prevention is always better than correction or cure. So we have come to the end of this webinar. And here I've stated that litigation proofing your startup is a non-negotiable. You cannot negotiate it. And so for any startup founder listening to me right now, for anybody who is intending to incorporate their startup, audit your current structure. So what current structure do you have? What gaps can you identify? Fix them and fix them on time. And engage your lawyer proactively, engage your attorney proactively. Um, don't wait until there's a problem. Start asking questions. Start booking consultation sessions. Start asking them to audit your company's profile, audit your plan or audit your structure. Don't wait till things have gone bad. Again, prevention is always better than cure. So thank you very much, and I'm open to questions. Thank you very, very, very much.
Okay. Thank you so much. Thank you so much, Barrister Hilda. This particular session is one that I do not think any single strategic founder should miss. Now, we have a couple of questions, but for our time, we would be asking just a few of them. Yes. So, the first question is, um, what would you say for a startup that is just beginning and is trying to balance the cost implication as well as the necessity for all the legal requirements for litigation proofing that you mentioned. So, how do you think this balance can be achieved? That's the
Okay, could
first
you please
question.
repeat? Could you please repeat that question? I didn't hear properly.
Okay, so this person is trying to ask, right? When they began their startup with low costs, low finance, low budget, and every single thing, and then it seems that the whole checklist for litigation proofing has some form of cost implication. So the person is asking, how do you bridge that gap between what is actually necessary and what is, just a stretch for a startup that is just beginning in terms of their finances? So how do they create this? How do they bridge that gap?
Okay. Okay, so thank you for that question. When it comes to starting your startup, there are two inevitables. The first is, of course, registration with the Corporate Affairs Commission, and the second is contracts. So start from the incorporation part. Many founders don't, or many startup founders, startup owners don't put too much thought in what goes into their memorandum and articles of association. The truth is, the articles of association, they are contracts. They are legally binding contracts. So start from there. So the first thing is, you want to engage a CAC agent to register your company for you. Maybe on the average they will charge you 70,000, 75,000 naira. I'm using that as an example. If you get a lawyer to carry out that incorporation for you, so let's say at the very least 150,000 to 200,000. Now you have paid 2x what you would have paid um a regular CAC agent. But against the backdrop of, or against the background that this lawyer would help me edit my memas, so they can look at your articles of association, and based on the business structure you intend to have, edit the model articles, because we have what is called model articles. Model articles are articles that the CAMA already makes available to you, and what the typical agents do is that they just copy and paste. They don't edit anything, and then they register your company with the model articles. But see yourself sacrificing 2x of that payment. Hire a corporate lawyer to edit the articles of association. So that already stands as a contract for you. The flip side is, you don't edit your articles of association, you have a shareholders dispute, and you are paying 1 million, 2 million, 3 million, 4 million in litigation fees. So look at it from the perspective of, I would get a lawyer to carry out my incorporation. I'm not going to use an ordinary CAC agent that has no idea on the law, or has no idea on how to properly structure my incorporation document. I'm only going to pay times two, but the times two is going to save me a possible 4 million naira, 5 million naira, 6 million naira in the future. The second thing when it comes to contracts is, I, I tell my clients also that it's a matter of conversation. The truth is, law is not cheap. Legal services are not cheap, and they're not supposed to be cheap. A lawyer has gone to school for 6 years. It's a rigorous training. It's a lot of upskilling that happens afterwards. It's a lot of learning, consistent training, consistent, continuing education. It's a lot of work. However, there are alternatives. You can talk to your lawyer to say, okay, can you provide me, rather than a retainership that might be expensive for my startup, because at this point in time I may not be able to afford a retainership. I might also not be able to afford one-off, because let's say a lawyer charges you 250K, 300K, 400K per agreement, and that's not something you think that you can afford. Why not speak to your lawyer, your attorney, to create a template for you? Now they can charge you a one-off very high fee, maybe 700K or 750K, to create a template for you. Maybe three, four, five templates: an employment contract template, an IP assignment template, NDA templates, and they create that for you. And all they do subsequently is just review. So you are not paying, for example, 300K per contract or 400K per contract. You're just paying a one-off 750K flat fee, and they create 8 contracts for you. And then you pay a minimal fee afterwards to have those contracts reviewed as you use them continuously. So the benefit for you as a startup founder is you're using one contract maybe for 6, 5, 7 transactions, but you only pay a one-time fee for it. So those are conversations you can have. They are cost cutting measures. But I will always also advise any startup founder, don't go for cheap, because cheap never helps eventually. However, there are cost cutting measures you can put in place. Like I said, the template measure, the template example is a cost cutting measure, and then hiring a lawyer for your incorporation process is also a cost cutting measure. So I don't know if that answers the question.
Yes, ma, that was very, very clear and straight to the point. And speaking of conversations, because I particularly liked the point about having a conversation with your lawyer with respect to cost and all of that. So how can founders have difficult conversations about equity and control without damaging relationships? Because we know oftentimes these startups, they begin by, okay, people who are already somewhat familiar. So how do we move from that level of seemingly being over familiar to actually getting formal and documenting this, what needs to be documented, about equity, control, and whatnot, without damaging the existing relationship?
Okay. So the truth is, as a founder, you need to tell yourself, or you need to um know that Nigeria is a low trust environment when it comes to business. You cannot, in business, you cannot take people at their word. And you cannot, because of familiarity, fail to not put contracts or documents in place that protects you, that protects the company. Now, the first thing is disassociate yourself from the company. The company is a person on its own. So, so there are two people in focus now. There's you, the founder, who has to protect himself or herself, and there's a company that cannot talk, speak, but only has actors and needs to can be taken advantage of and also needs to be protected. So, having tough conversations is inevitable. That's the honest truth. If you're looking for long-term growth, if you're looking for sustainability, then those tough conversations need to happen. You can't bypass them. And I guess first, many times the tough conversations come from trying to start a funding round. If I'm too strict, this person will not give me their funds. Don't get yourself in a desperate place. That's the counsel I give every client I've ever had a conversation with that is trying to raise funding. Don't be desperate. When you get yourself in a desperate position, you don't have bargaining power anymore. So first, if you're trying to raise funding, try to look for low cost funding. So raise funding from family and friends. If possible, start with debt funding. There's really nothing wrong with raising via debt. With family and friends, interest is usually very low. So single digit interest rate. Let that let that be the first capital injection in the business. Raise via debt. It doesn't always have to be via equity. And once the company has been able to stand a little bit or is able to, operations are ongoing, they are predictable, then you can transit into equity. But those tough conversations, they're inevitable. Yes. So I don't know if that makes sense. I hope it does.
Yes, ma, that indeed perfectly answered the question. That perfectly answered the question. Thank you so much, Barrister Hilda. It has truly been knowledge packed having you take us on this session today. Now to our audience,
Thank you so much.
let's soak in what we have learned so far. Now, we have seen that building a startup is often described as a race against time, against competitors, and against the uncertainty of the market. Founders are encouraged to move fast, experiment constantly, and focus relentlessly on growth. In this environment, legal considerations can easily appear secondary. They are often viewed as administrative tasks to be handled later once the company becomes larger, or maybe once the company begins attracting investors. But as many founders eventually discover, the legal structure of a startup is not something that can be postponed indefinitely. The absence of strong legal foundations does not simply create inconvenience, it creates vulnerabilities that can surface at the most critical moments in the company's journey.
Okay.
Litigation rarely emerges from nowhere. Most disputes are the result of unresolved issues that existed long before anyone stepped into a courtroom. Founder disagreements that were never clearly structured, contracts that failed to define expectations, intellectual property that was never formally assigned, workplace policies that were never established, or regulatory obligations that were quietly overlooked. All of these small gaps can accumulate into major legal conflicts, and by the time a dispute becomes visible, the underlying problem has usually been developing for months or even years. This is why litigation proofing must be understood as a proactive discipline rather than a reactive response. It's not about preparing for lawsuits after they arise, it's about designing systems that reduce the likelihood of disputes occurring in the first place. The most resilient startups are not those that simply hire lawyers when trouble appears. They are the ones that integrate legal clarity into the architecture of the company from the very beginning. Now, having dealt with litigation proofing your startup this month of March, we would be interrogating another very interesting theme next month, April. Now, the theme for the month of April is advanced IP and tech monetization. I know, but just as excited as you are about this theme. And we will be having the exceptional barrister Elijah Briggs dissect this theme in our next month's webinar. I can assure you, this is one that you do not want to miss. Thank you once again to our speaker, our host, and to everyone who joined us today. We are certain that you gained value, and we certainly look forward to having you again next month. Thank you so much, and do have a lovely day.
Thank you.